We're on the live stream. Okay. All right, Miss Anna, thank you so much. Have a good time. Okay, bye. Anybody know who Susan is? Mr. Begacco, do you know who Susan is?
Madam Hearing Examiner, can you hear me?
I can.
If it is Susan Miller, she's an attorney with the Model Sperling Law Firm and has entered her appearance in this case on behalf of LES, along with Ms.
Okay.
Joan Drake.
Thank you.
And I will recognize her. I'll tell you if it's Susan Miller or not.
Just in case it's an imposter.
That is Susan
Well,
Miller.
All right. Hi, Miss Miller. I'm like, who's Susan? I don't see a last name. Who is that person?
Yeah, sorry. I've been trying to figure out how to put my last name on there. I'll have to do that at some point.
Yeah, the court reporter was asking me about that the other day. I just want to let people know you are we're live streaming already on YouTube. Anna has that set up. Do we know who Charles Day Salion is?
Yes, Madam Hearing Examiner. I believe he is an attorney for CCAE.
Okay.
Don't test me on everyone, though, please.
Okay. Why isn't my arrow cooperating? Okay. Miss Lees? Josh, Mr. Rushoff, I know. What about Josh Smith?
I believe Mr. Smith is with the Sierra Club.
Okay. Mr. Oldham is familiar. Okay, just to let people know as you sign on, we are live streaming on YouTube. Are we still continuing from last week, Miss Lise? Is this a new case?
New matter.
New matter, new matter. Right, because I actually have a separate Miss Hardy from a separate Miss Lise.
That's right.
I'm not
Yeah, the court
impersonating
report-
her today.
She probably was charging you rent, but you can charge her rent on that puppy you're gonna let her borrow.
You're right. I think I will do that.
I'm still working on that. Let's see. Yeah, the court reporter was actually talking about wanting to change her name, and I could go in and change it, but she couldn't go in and change it. So I think I have to look at those controls. About allowing people to change their names. Okay, we're getting close to, well, the state issued phone says 1:30, so looks like we have people that I expected to see, and so we'll go ahead and I think the top row, Miss Lisa, Miss Hardy, you're here for SPS, and I think Miss Trammell's here too.
Correct, Your
Although
Honor.
you could be watching us on YouTube. Major Buchanan is for FEA. Miss Miller and Miss Drake are for LES. There's Mr. Getko in the corner, not off skiing. So he is for the Attorney General's office. Mr. Bagatko for staff. Mr. Moffat, who do you represent?
Good afternoon, Your Honor. I represent COG Operating.
All right, sir. And the gentleman next to you, I'm probably going to butcher your name, sir, but it's Charles De Salion.
DeSalen. Thank you, Madam
DeSalen.
Hearing. Yes,
Hello,
correct.
sir.
I am representing the Coalition for Clean, Affordable Energy. Thank you.
Very well. Okay, that takes me through the second row. Hello there, Mr. Rushoff.
Examiner Hurst, how are you?
I'm okay. How about yourself?
Doing pretty well. I am here with the New Mexico Large Customer Group, and my colleague Austin Jensen is also on the line.
Very well. And Mr. Oldham?
Yes, Your Honor, Philip Oldham on behalf of Occidental.
I thought I saw Mr. McMillan there for a minute. Nope.
I don't know if he's going to be joining or not.
Okay. Hello there, Mr. Marks. Unmute yourself and say hi.
Oh, I thought I was doing that thing with the space bar, but it wouldn't cooperate. Good afternoon, Ms. Hurst.
Hi,
I'm here
who are you
for-
here?
I am here for Sierra Club and Josh Smith, whose disembodied name is somewhere on my screen, is in-house counsel for Sierra Club.
Okay. Very well. Nee. Okay, well, I think that has got everybody. I think all of our appearances. Welcome. I was just kidding, Miss Lise. Again, I'll remind you for the last time, you are being live streamed on YouTube. Also, hello there to Ms. Leva Tercero for staff.
Hello.
I was just asking Miss Lisa and Miss Hardy, if we're continuing, we went 3 days last week. So I don't know, then I had like a 4-hour Zoom meeting after that. Feel like I'm a Zoom fatigue, but I thank you all for your participation here today. We are here with regard to SPS's new rate case 22-00286. And my understanding is that you all, excuse me, I knew that was going to happen, that you all have been contacted and provided a proposed schedule for this case. That was the main purpose of the reason for me wanting to have a pre-hearing so close to the holiday season, because I wanted to go ahead and be able to get the notice in the works and the procedural order so that this case could get going in and I noted in looking in the info share that people are letting no grass grow under their feet. And I already have 5 motions to intervene. Ms. Lees, Ms. Hardy, have you had an opportunity to review those 5 motions to intervene?
Yes, I have, Your Honor.
And are there going to be any objections to those?
No, Your Honor.
Okay. Well, I reviewed them, and if there's no objection to them, then I'm going to go ahead in the procedural order and grant the motions to intervene for FEA, for Occidental, for the Attorney General's office, for LES, and for the New Mexico Large Customer Group. The only thing, before I ask if anyone else has anything procedural, the only thing that I wanted to discuss with regard to your proposed schedule is your end of suspension hearing, end of suspension date.
Yes, Your Honor.
And if you look at the commission's designation order, and or as it was referred to, the initial order suspending advice notice number 312 and appointing hearing examiners, they actually in paragraph A say that they're beginning the initial suspension period for a period of 9 months, and then it commences on December 19th. So if you go into the date, time, free calculator, and you add 9 months to September 19th or December 19th, you come up with September 19th. Can you tell me how you came up with December 18th?
As opposed to September 19th,
Yes.
it must just be some way we did the date calculator that's a little different than how you did yours.
Okay. And I'm just doing mine based on the commission's order beginning the suspension period on the 19th and then adding 9 months to it. And it comes up with Tuesday, September the 19th.
I'm going to my date calculator now.
Okay.
I trust that your calculation is correct, Your Honor.
Well, obviously we wouldn't want to blow something like that. So I just want to make sure that everyone is in agreement that if the 9-month suspension date was fully utilized, then the commission would have to have an order on or before the 19th of September. Is anybody opposed to that? You're eyeballing your computer there, Miss Lees.
I know, I'm looking, I'm trying to figure out what we must have done differently.
Well, what's
Um,
interesting is the suspension date, the 30 days from when you filed on November 18th actually would have run before the 19th, but it was on a Saturday and Sunday. So the commission began the suspension date on the legally operative date, the business day of the 19th.
I guess I should
So I
check
don't-
with my client to make
Okay.
sure that they do not have, I don't know if Brooke can make that call on this call.
Okay.
and Text me maybe or speak up, but if there's no objection to the 1 day difference. If
Okay,
there
well,
is,
you will be checking that out,
thank you.
because that's something really important that we need to make sure that we have in line. And again, I was sent a proposed schedule. Is there anything that anybody else believes that we need to discuss today other than a procedural schedule? No.
Madam
Okay.
Hearing Examiner, I just
Yes,
wanted
sir.
to point out, and this goes back to you, the previous discussion, but I just wanted to point out that Coalition for Clean Affordable Energy will be filing a motion to intervene in the next day or so.
All right, sir.
There have been no
Thank-
objections.
All right, thank you. Miss Lees, was there any attempt to ascertain what kind of time period that you believe if this remained fully litigated that we would need to set a hearing for?
My working assumption is usually fully litigated rate cases, in my experience, have gone for 2 weeks.
Okay,
Um,
so then potentially you would be looking at the week of June 5th through the week of June 12th, ending on or before the 16th. Is that correct?
That's correct, Your Honor.
Okay. Okay. Has everybody had an opportunity to review these dates, and does anybody have any commentary on these dates? Or is everybody in agreement with these dates? While people are thinking, Ms. Lees, when is SPS's expectation that you're gonna have the notice from me in order to be able to comply with the publication and mailing of January 11th?
My understanding, we need that notice from you at least a week before the publication deadline. So the publication deadline, I believe we have is January 11th.
Yes.
So if we could have that from you by the 3rd or 4th, that would be sufficient.
Well, hopefully I could get it to you this week. So
That
I
would
don't
be
know. Would you
great as
plan
well.
on going ahead and accomplishing this early, or is it still going to be the 11th?
If you would like to push that notice deadline up earlier and can get us the notice in sufficient time to meet that deadline, then we can do that as well.
I probably, since I don't know what any holiday time deadlines are for publication, or if they even have those anymore with the internet, I probably would just include language to say to, to publish, as soon as practicable, and no later than the deadline that's proposed, if there's no
Okay.
objection.
Yes.
Okay. Mr. Begatko, with regard to the staff testimony deadline, in conjunction with well, first of all, it's your belief that staff would have the opportunity and enough time to conduct any discovery that it needs on this case with the current proposed April 3rd deadline?
Madam Hearing Examiner, we've reviewed the proposed schedule, and that was one of our considerations. And I believe we will have enough time to conduct discovery. As a point of fact, we already have some written discovery issued right out of the gate to SPS. So we're trying to make the best of our time, and we think we can make the schedule work.
Okay.
Hearing Examiner Hurst.
Yes, sir.
This is Austin Rushoff, New Mexico Large Customer Group. I had one comment on that deadline and the related rebuttal deadline. It seems like in the schedule with the stipulation deadline of May 8th, that's pretty close to the rebuttal testimony deadline. I was going to see if the parties would be interested in giving us maybe a little more time after rebuttal to see if there's an opportunity for a stipulation. And to do that, I might propose moving the staff and intervener testimony deadline forward 1 week to March 27th, and then equally moving the rebuttal testimony deadline forward 1 week to April 24th. Just an idea for the group's consideration.
And SBS is fine with Mr. Rushoff's proposal and does not object to it.
Well, how did the parties affected? How does staff and the other intervener parties, how do they feel about having a week taken away from their time deadline? Mr. Pagacco?
Staff would like to keep the week, to tell you the truth. I think if there's some other way to accommodate that concern by not taking away time, but doing something else, I think staff would be amenable to that.
And I'll say that's fair. I didn't have a chance to run this by most of the parties before I brought it up, so it's kind of a surprise attack here. It's not something that we're adamant about, but just an idea.
Well, and I guess the other consideration that I have is I really don't want to be put in a position again where I vacate the staff and intervener direct testimony deadline because it's so close to the stipulation testimony that it doesn't make sense to go ahead and file it because there is a stipulation. So I just wondered whether or not, you know, having these dates where they are, whether or not staff and interveners think that I might be back in that situation again in this case.
Madam Hearing Examiner, we sure do not want to put you into any kind of situation like that, or a situation like we had, what was it, a couple rate cases ago. We want to abide by our deadlines, and we want to make sure that this is procedurally copacetic for you. So we're very interested in not having those kind of things happen in this case. If people are interested in carving out a little more space, I think we're open to that. It's just that based on my feedback from staff, don't want to give up time on our deadlines, especially, you know, even a week to staff lately has been terribly consequential. So I'll leave it at that for the moment.
Okay.
Thank you.
What about Major? Any thoughts from your perspective on the proposed schedule or any change to it?
I mean, I think we could make the earlier timeline work for the intervener testimony if that's what is agreeable to the parties. So I think we can be flexible.
Okay. What about you, Mr. Gedko? Any opinion on,
I have some reservations that are in a similar vein to staff's reservations. This isn't the only rate case right now. It's expected to be a very busy spring, especially for our experts that will be involved in more than one matter. And I'd want to, at the very least, check with them. I was writing some text right now, but off the cuff, I have some hesitation with taking time away from the time that's available to produce testimony. It's a extensive filing.
yeah, that was actually going to be before I got on this, that it was actually going to be one of the observations that I made. And again, at this juncture, I have not made an extensive review of the filing yet. But I did notice in the proposed notice that there's quite the Christmas wish list in the notice of all the things that SPS would like from Santa this year. A lot of regulatory asset changes, and I think in the like 9 or 10 things. So all humor aside, I mean, there is going to be a lot of there's a lot of information that's going to have to be reviewed, and so, but since I'm looking at the notice, well, no, I don't want to switch topics. Let me go ahead and go back to Ms. Drake. Do you or Ms. Miller have any opinion on whether or not you'd want your week shortened?
Well, I'm of two minds about this. As usual, on the one hand, I agree with Mr. Royshoff that it's always worthwhile to leave open a real possibility for settlement in a case like this, and that usually takes at least a few more days than we give ourselves. So we always feel like we've got a gun to our heads. On the other hand, I completely understand you don't want a gun to your head, nor does the commission want to be squeezed on the back end. So I'm wondering, even a few days for us to discuss settlement after SPS files rebuttal may be worthwhile. So I'm wondering if we can't shave a week, I'm wondering if we could shave even 2 or 3 days to allow us to have our experts look at the rebuttal position, assuming there might be some change, analyze that, and then get together so we can talk over the details. Does that, I mean, I guess I'd throw it out to you and everybody else. It seems like even a few days, maybe to like April 26th instead of, I'm sorry, if we could maybe move rebuttal testimony up even to like April 26th or 25th instead of May 1st, and then keep the stipulation date at May 8th, that would give us a few more days.
And SPS is fine with that as long as the staff and intervener deadline is also moved at the same amount of days.
And I'm flexible on that too. I think we're going to have 3 full months to prepare our case and do discovery and so on. So I think the loss of a few days for us it's okay with LES, but I sympathize with staff. I understand what they're going through as well. So I'd say that LES is okay with that, but I understand staff's predicament as well.
Okay. And I was sort of thinking that way, if also, Ms. Drake, is that maybe if it couldn't be the full week, that maybe there's could be some movement of a period of days that I'm willing to look at. And then did I lose all my little Mr. Stoffel, the large carrier group? I lost you.
I don't see him either.
Any thoughts from any of the other purported interveners?
Your Honor, Philip Oldham for Occidental. We're fine with what Ms. Drake is proposing. Think something in the middle probably makes the most sense.
Okay. Very well. Okay, well, I will think about that. But the rest of the days, obviously might have to slide a bit depending. Kind of don't want to mess with that too much, but I will keep that open. Let me ask, just to let the parties know, as I usually do include in a notice, I always like the customers to know, and depending on who the utility is, whether they call it a typical customer or an average customer, I kind of like a sentence that gives the bottom line of what's this going to look like to me on my monthly bill. And so this morning I emailed Miss Lisa, Miss Hardy, and said for the pre-hearing, I would like, I'd like to have that information. And Miss Lisa called me and told me that it was in the notice, but that she would put something in some sentences and send out. And I believe, Miss Lisa, you sent that out to the parties?
That's correct, Your Honor. The bill impact tables identify the average customer in those tables. Those tables, though, provide the bill impacts during summer and winter months separately. We provided you a narrative of the annualized bill impacts for the average customer.
So, for example, when I begin on 3, when I start getting the charts of the proposed notice, tell me how I would identify that. Where it says average?
Yes, that's correct.
Okay. Okay, so that's the average of the winter, average of the summer.
The average customer bill impact, yeah.
Okay. And what the narrative says, okay, so if I were looking at the residential customer at 900 under summer months, it would be 10.4. And for winter months, it would be 11.8. So then you just averaged it to come up with 11.3.
I have to admit that I do not know how to annualize those.
Okay, but yeah, the verbiage says, okay, okay. $13.77 at 11.3. So, and that's the inclusion of both the increased customer charge and the actual KWH charge, correct?
I'm sorry, can you ask one more time? That's the
I can. I want the overall average for that customer. And so that would be the 11.3, which includes the KWH increase and the customer charge increase, correct?
KWH increase and the customer charge increase.
Right.
Madam Hearing Examiner, I'm just going to have to talk to my subject matter experts to confirm how they annualize those numbers for you. I didn't do the
Okay,
calculation.
so for example, the service, what you call the service availability charge, I call the
Mhm.
customer charge, that's
Mhm.
24.5.
Mhm.
Okay, so when you add that with your 900 kWh and you have that new proposed rate, I just want to make sure that that average, that 11.3 contains all the increases that average or typical customer would see if they took service under the residential service rate.
Okay, and I can confirm that, and if what we provided you does not include the service availability charge, I will have them change what we provided you for.
Okay. Yeah, I want not just what they're going to see. I don't want to just see the KWH. I want to see the whole percentage increase with both the KWH and the service availability charge proposed increase. How that customer would be affected on a monthly basis. I
And
also wanted to.
are you okay with the annualized, that being annualized?
Yeah.
Okay.
Yeah. For your rate classes where you have different rates, absolutely. For different rates for summer and winter.
Okay.
I did want to ask you though, in your proposed notice, why are some of the numbers in gray and some of the numbers are in white?
I do not know. I think that was just how it was formatted. My assumption is for ease of reading the table.
Okay, so it doesn't mean that that the gray and the white don't denote anything I should know.
No, I think there's just no like lines around the table
Okay.
provided in the notice, but they wanted to show that in some way, but that was not as busy as each cell having an outline.
Okay. There's not like some implanted subliminal messaging that says, approve me, approve me.
I don't think so, Your Honor, and I certainly am not that sophisticated to include that in the proposed notice.
Okay.
But I'm gonna
No,
check on that. That's a great idea. Thank you very much. I'm gonna check on that.
Well, obviously I'm kidding about that, but I did think, there's probably an asterisk or something that tells me the gray from the white, and I'm just not seeing it. So after, spending some time looking at it, I thought, well, I better just ask.
Yeah, I think it's just there so that it's a table that's easier for people to read.
Okay. Okay. I do want to let you know that the notice that does come out will have some changes in it in an effort to have a more standardized notice from the hearing examiners. There will be some changes that are made primarily for me. It will be to make sure that we're all using the same contact numbers, for one thing. There seemed to be some confusion, and I accepted the responsibility for that confusion in the case that we're going to hear in a couple weeks. And the confusion led to some phone calls to our ASD department, whose number was listed in the disability section, and also to the consumer persons who might not necessarily have been equipped to answer case-specific information. So we usually have, for some of the phone number notices, we have our assistant, Ms. Keppenbrock, to get those calls. And then we also are, I'm changing after speaking with Mr. Borman, who happens to be the ADA coordinator for the commission. His number, at least for the time being, will go at the end of the notice as the person to contact for any assistance. And this is not in his role as legal division director, but it is in the role of the ADA commission's ADA coordinator, which he is. So there's going to be little things like that that you see are a bit different. I'm also going to move the dates, the intervention dates and hearing dates, those kind of things are, to the extent that I can, they're going to be moved forward. Because especially, as you know, in rate cases, with all the required comparisons and rate tables, by the time, you know, in, for example, SPS's proposed notice, you know, by the time you're like 5 or 6 pages back is where you get to that information. That's not going to be the case. So we're working on these. We're trying to streamline them. We're trying to listen to feedback that we get, and we're all trying to have the same communication and telephone numbers, so that if anybody does have questions, that they're either going to get to the company or they're going to get to the part of the commission that can help them get the information without having to go to 2 or 3 different two or three different phone numbers. Okay. As I have been instructed, the notice will contain that this is going to be a Zoom hearing. Should that change, with, as you know, a new commission in the new year, depending on their considerations, space considerations, etc. I will let you know as soon as I know, should that change. But right now it's going to be noticed as Zoom. Let's see. Additionally, so does anybody have any questions so far on the proposed notice or our proposed schedule? No. Okay. One of the only other things I guess that I wanted to talk about at this juncture is also perhaps just a more uniformity or formalized procedure for Zoom participation. I can only speak for the hearings that I have run, and I can't tell you because I've not had the opportunity to view any of the other hearing examiners' hearings. But I can tell you that from my experience and in discussion with the other hearing examiners, that there is going to be an effort. We put in the pre-hearing orders that the conduct shall be as if it is in a hearing. That's not always occurred in the Zoom hearings. I believe there will be an effort to make sure that that happens. So, for example, if you're required to be on video, as we require the attorneys and the witnesses, it means you're not going to be able to turn that video off unless you have permission. With regard to your witnesses are going to need to make sure that they are in just as in a hearing room. In a hearing room, a witness would not be sitting there chewing gum during the entirety of their testimony. So again, some of these things that perhaps I may have overlooked or not been as strict upon, I can tell you now that having the Zoom hearings conform as much as they can to an in-person hearing will that's what's going to happen in a going forward manner. So, again, doesn't necessarily relate to anybody that's sitting here today, or it might if if it sounds like you or sounds like your witness, then okay. But like I say, I mean, I understand, if people have been like me and the dog starts to bark, or I don't know, what was it? I don't know if it was the trash truck outside the window. Obviously, there are things that can happen and people can ask to be excused. I totally understand that. And we can deal with those things. But so enough said on that. And I guess it sounds like that if no one has anything further, I do understand. Yes, as Mr. Gatko and I believe also Mr. Pregatko pointed out, there's other commission cases, maybe even commission rate cases that are going to happen. I think our rate case is important, and I'm going to do my best to make sure that we get the time we need and get our case going. So that's why we're here now, going forward. And if we don't have anything else, the only thing
I do have something else.
Oh, okay. Mr. Marks is pointing.
I was waiting, but I wasn't sure if you could see
that little hand going up, that we had last week. I thought that was cute. Yeah, with that little hand. But yeah, so the thing I'm thinking about right now, like I say, is trying to tweak some days a little bit to give a meaningful opportunity for for you all to have any type of stipulation discussions. And Ms. Lees, you wanted to ask?
Yes, Your Honor. I just wanted to say that the September 19th as being the end of the suspension period, folks were looking into it on our side, and that's fine. It sounds like that's correct. So
okay, well, if it's wrong, I want you to tell me it's wrong.
Folks were looking into it. It was hard for me to do it on the fly.
Sure.
In the hearing.
All right, well, people
also-
are okay.
Yeah, also, we will, I will follow up with you on whether the narrative bill impacts what was included in that narrative. in
Okay,
bill
the
impact.
customer charge. Okay,
Yes.
yeah,
Also-
again, whatever we can do to just put the information out there in as streamlined a format. I mean, I sound like a broken record and I don't mean to, but I mean, that's always the goal is to try to get people the information. Cause it, it suits us all to do that.
Yeah.
We don't want to come back later and have somebody try to hold something up because, they're like, hey, we didn't get adequate notice. I mean, because that's going to affect us all negatively.
Yeah, agreed.
Yeah. Something else, Miss Lise?
Your Honor, SPS did want to discuss one other procedural issue with you.
Okay.
If you have the time to do it right now. In case number 20-00238 UT in the procedural order in that case, the procedural order in that case contained language regarding the tolling of the suspension period in the event that parties reached a settlement in the case.
Yep.
And SPS would like to discuss whether, Madam Hearing Examiner, you're willing to reconsider that language as after the last rate case, it is now becoming an obstacle to SPS settling this case.
So I take it from your comments that if the hearing examiners continue to utilize that language in the procedural order, SPS is going to object to it.
We would like to discuss it with you. It is creating a hurdle for us in terms of settling the case, knowing that the suspension period will be tolled and we'll have rates later than expected. And we wanted to discuss that problem with you and with other interveners in hopes that maybe we could come to a solution that will address your concerns.
Well, let me ask you this, Ms. Lees. How much of a time frame does SPS believe it was how many months to its detriment from what the commission could have suspended the case for? Did the commission ultimately decide the case in? So how many months do you believe you're disadvantaged?
I believe we got a final order in that case a couple months after the suspension period, the original suspension period had passed, Your Honor.
Well,
and
so
I'm just not remembering the exact number of months. But I can look that up.
And I don't know if I can. I don't have the setup with this computer.
And again, respectfully, Your Honor, we understand that we want to provide the hearing examiners with as much time as they need and the commission time to consider these cases, but this is an issue that we would like to explore with you because it is an obstacle to settlement for us at this point. And
it's an obstacle because you think that you have less incentive to settle because you know that your case is going to be suspended during consideration of the settlement?
The suspension period will be told. That's correct, Your Honor.
Hearing examiner Hurst, if I could, I could weigh in a little bit just from one intervener perspective. We have talked about this with Ms. Lees and SPS before, and as someone who advocates for customer interests, we don't necessarily have a problem with SPS's rate increases going to effect later than they might. But we do see this policy as, kind of putting a chilling effect on the utility's interest in engaging in settlement conversations as essentially, I think the way the policy works is that as soon as SPS agrees to a stipulation, they essentially have no kind of certainty of when rate increases may go into effect. So we do think it's something that's kind of is tough procedurally for the company, and for that reason, we think it hurts our ability to have meaningful settlement discussions.
And just
Okay.
for what it's worth, I would agree with that I think there's value, as I've said before, I think there's value in the parties being able to seriously get into settlement negotiations. And so if this is something that really impedes that, I sympathize somewhat. And there's always, I think, the possibility of getting into an agreement on an extension of suspension versus just tolling completely the suspension date. That might be more acceptable, I think, and maybe not be as much of an impediment.
And just trying to get a time frame. Any other party wish to opine on this?
At the risk of making everybody mad, there ought to be a difference between a contested and an uncontested stipulation. If the company was able, as it did in the last case, to reach a stipulation with all the parties, it really wasn't fair to the company that the commissioners strung them out on it, on a final order. Whereas if the company comes to Your Honor with a contested stipulation, I think Your Honor is should be concerned that in the event that the stipulation is not acceptable, that you don't get your back against the wall again, as happened several times in the past. So I just offer that maybe there could be a different maybe you can give the company an incentive to come with a complete stipulation while protecting your time in the event that there's more likelihood of a contested case.
Okay, anything from anybody else on that? My understanding, I believe, as to why the commission instituted this procedure was that the commission wasn't being given the opportunity to consider the stipulation or potentially return the stipulation reject it and send it back because there wasn't any time left. That basically the parties were utilizing all of the time and then offering up a stip, and the commission was then basically a take it or leave it position. And that this actually allowed the commission time, should they decide, like they did in 20-00238, that they wanted it sent back and reheard, that they could do that. Or in a rate case situation, they could just reject the stipulation and just have the case in chief heard. So just in doing a quick look as I could on InfoShare about last time's case, I mean, it looks like to me that the case, the case was filed like sort of like this case instead of November. That case was filed in December. There was a suspension order and in the middle of January of 2021, and SPS got a final decision of the case in February of 2022. So that's pretty darn close to that 12 months that the commission had to suspend that case, isn't it, Ms. Lee?
I'm sorry, Your Honor, without just seeing and I should have admittedly mapped this out for myself before, in anticipation of us having the discussion on how much time actually did pass, but I do know we received a final order after the suspension period had ended.
Yeah, and like I say, and I'm just going from your numbers that I'm picking up in InfoShare. And like I say, the filing in December of 2020, the initial suspension order was January 13th of 2021, and you got a final order in February of 16 of 2022. So it doesn't look like to me that there was much time really, if SPS had no stipulation. So, but I understand, I mean, the whole purpose of the stipulation is to try to cut off some time, and that didn't happen. Okay, I acknowledge that, but again, if the commission has the power and authority to suspend rates for a year, it doesn't look like to me that you are too much outside of that year from your filing. So, I mean, I'll think about it. I hear what, the parties are saying, that yeah, it may be a disincentive for the company to want to settle if they don't think they're going to get some particular time advantage in doing so. But I mean, it's kind of like a question I think that's come up actually didn't come up in it did not come up in this case. It actually came up in the New Mexico gas rate case that was just completed. And essentially, they've gone through a period of stipulations over the past 5 or 6 years. And they file for a big number and then they settle for a small number, but then they just refile again. And you look at the rate case expenses that each one of those cases take, and you kind of wonder, wouldn't it be better if they just stuck to their position and just went ahead and advocated for the increase they really thought that they should get, rather than settling for lower percentages over and over again, and tagging on all these rate case expenses. So, I mean, I think they're, I mean, SPS files every 2 years, right?
We have been doing that, Your Honor, yes.
Yeah,
And,
you know,
and we are
and-
trying to mitigate it with a future test year case in this filing. And again, we certainly understand the concerns. We wanted to make you aware of our concerns, I think, that are shared with some of the interveners here as well.
No, and I appreciate that. And obviously I'm willing to think about it. But again, without actually, you know, I don't know. I don't know if it's something that we need to have legal briefs on, if that's, you know, what's going on. I mean, I don't know if we want to go that route, or we, you know, we'll have to think about going ahead and including it. And then obviously SPS could object, you know, to that particular language.
Mhm.
I don't know. I'll definitely think about the perspectives of the parties on this issue. At this point, I'll go back and see what I can find from when we initially started this. But I think at this juncture, I don't know that I can change it.
Okay.
I'll consider it, but I'm just giving you for a warning that I don't know that I can change the because of why it was put in there and who wanted it put in.
Okay.
Okay.
Thank you, Your Honor. And like I said, we just wanted to raise this to you because it is a concern of ours. One
Okay.
other procedural matter, Your Honor.
Sure.
SPS had filed a motion for protective order in this case. And as we have
Okay.
received discovery, it would be useful to have a protective order in place before we answer
Okay.
that discovery.
All right. Will you send me that pleading, please?
Yes, I will.
Okay, I'm not in that case. See, and I thought that's what you were going to ask me about.
It was both.
One of those things. Okay. Let me see if I saw that. Okay. Very well. Do we have anything else procedural that we would like to discuss? No. Okay. Very well. Well, I appreciate your time, and I will get the procedural order and notice issued as quickly as I can. My hopes are to get this finished this week. Should anybody need anything to do with this, you can contact me. And otherwise, Ms. Lees, I will be expecting an updated narrative on the exact effect of what SPS is requesting. And if nothing further, I thank you all very much. I hope you have very, very happy holidays. Mr. Getko, I
I'm
know you
noting-
want to leave. You want to ski.
No, I'm noting that Mr. Marks has his hand up.
Okay, there you are,
Uh,
Mr. Marks.
Yeah, Ms. Hurst,
Are you
I
waving?
thought about, I was waving goodbye,
Okay.
but also I thought about it further, and Sierra Club is not a party at this point, but we would support what, I retract what I said about different kinds of stipulations. I think I would support what Ms. Lee said. And I think it's consistent with the equities in the Public Utility Act that they've come to you with a schedule that gives the commission plenty of time to within the original, the 13 months of suspension, to reject the stipulation if it's no good and have a hearing on the merits. And what happened last time was that the commission hung this rate case up for over 2 months because they didn't like the stipulation, but they couldn't find anything they really could that was wrong with it. And that's what the legislature did not want to happen. They did not want the commission to be able to endlessly suspend a rate. And we could, representing consumers, we could understand why you don't want, why later is better than sooner, but that's not what the legislature wanted. They did not want an indefinite suspension. And I think if we have a good procedural schedule that gets a hearing with enough time to have another hearing, that you should, and I'm arguing that you should not impose that tolling because parties like ours would prefer a stipulation if there is a good stipulation to a litigated case, and we shouldn't discourage that. And we shouldn't change the equities in the PUA.
And I hear you, Mr. Marks, and I will take note of that. But if anyone knows the position of the hearing examiner in relationship to the boss, as a former commissioner, that we do what we can, hopefully within the facts and the law. And that was not my choice to further suspend that case. So I'll leave it at that. And if we have nothing further, thank you all. Hope you have very happy holidays and safe time away. And with that, we are recessed until our next procedure. Thank you.
Madam Hearings,
Everybody.
happy holidays,
Thank
everyone.
you.
Thank you.
Thank you.
Bye, everyone.
Bye.
Bye.